Hello, welcome to Law Awareness Weeks at CDC 2020, The Law and Me Stronger Together. This is organized by Law Society Pro Bono Services and the 5 Community Development Councils with the strong support of People's Association, National University of Singapore Faculty of Law, Singapore Management University School of Law, Singapore University of Social Sciences, and the Singapore Corporate Counsel Association. I am Serene, and I'm your host for this webinar. Today's webinar is Freelancing in a Crisis. Before we start, some housekeeping matters. Relevant materials for today's talk can be downloaded from the handout section, which you can see on your screen. If you're using a mobile phone or tablet, the icons should appear on your top right-hand corner. On your computer, you should see the icons on the right. Please download these useful materials before the end of the talk. Please feel free to ask any questions during the webinar. You can type them into the questions section and click send. Your questions will only be seen by the organizer. We will do our best to address them during or at the end of the talk. Please note that the discussion and any materials provided in this webinar is not intended to substitute or constitute any professional legal advice. You should consult a lawyer if you require specific legal advice. All right, with that done, I would like to introduce our panelists, Mr. Liansheng Wang and Mr. Jeremiah Choy. Liansheng is a partner with Bih Li Lee LLP, a lawyer and playwright who has presented commissioned works with Singapore Arts Festival, Esplanade, and more. Liansheng specialises in civil and matrimonial litigation. Jeremiah is a trained lawyer who left practice in 1997 to become a creative director, producer, and curator. He has been involved in both local and international events and productions. He is an advocate for freelancers. Liansheng and Jeremiah, thank you for joining us today. For today's webinar, we'll walk through 3 common case scenarios that freelancers may face. Let's move to the first scenario. Cancelled contracts. John is a singer. John and client A signed a contract for John to perform at a company event in December 2020. Client A told John that the event is cancelled as their business is doing badly due to COVID-19 situation. Worse still, John had hired a band to accompany him for the performance. Client B owes John money, but John did not sign any contract with client B. All communications were over telephone calls or meetings. Liansheng, for the cancelled contract, is John able to claim for any money or compensation from client A?
Hi, Serene. Good question, because I think that's the first thing that's always on the mind of freelancers when services are being provided. It really depends, just like what lawyers would always say. I think
Yes.
It depends on. I think it depends on, for example, what are the terms of the agreement, right? Even though there are no written agreements, if there's an oral agreement, what are the terms? Are there milestones provided for this contract? Has work actually been done by John for this contract? If there is certain work done, there is a concept of a legal concept called quantum meruit, which is to reasonably compensate someone for the work that is done. So briefly, these are the big areas that we should be looking at.
You know, I hear that there's this concept called force majeure, and sometimes contracts have a force majeure clause. Maybe you could tell us more about what is a force majeure clause?
Sure. So force majeure is usually you would see a provision in the contract that says, okay, if there's an act of God, for example, that renders the contract unworkable, or that the obligations can't be carried out. For example, there's a strike, all right, or there's a power outage, or in this case, sometimes even a pandemic, right, like COVID-19, and then the obligations can't be carried out. the force majeure clause will usually provide for what were to happen if such a situation arises. It could be a suspension of the contract for say 6 months, and then for the obligations to be deferred. It could be, for example, if after 6 months the situation doesn't improve, then it's an automatic termination of the contract. All right. So in layman terms, that's what a force majeure contract is. Force majeure clause is.
So it sounds like it's something that must be written in a contract. So if it's not there, it means you can't rely on it, or there isn't such a concept.
Yeah, actually, the force majeure concept is, of course, what comes out from the express wording in your contract. Sometimes force majeure clauses might not even apply to pandemics if the word pandemic is not defined as a force majeure event, right? If there's no contractual provisions for such an event, there is something called common law, right? Where it is a body of law that helps to govern human relationships as well as commercial relationships. And common law has the doctrine of what we call frustration. We'll be covering a little bit of frustration later, but in very simple layman terms, frustration is the concept where something has happened that is so fundamental that you can't continue carrying out your obligations under the contract. And then that is the event of frustration that might afford you some rights or some options for you to terminate the contract.
You know, in this instance, it's not a case where I noticed the company event is in December 2020. So it's not a situation where it's circuit breaker and the government said there is no such event. So in this case, the client is saying, hey, I'm impacted badly. I don't have much money. Typically, would financial difficulties trigger a force majeure clause?
Not really. Not really, because once you enter into a contract, you're expected to be able to fulfill it, right? You're supposed to actually plan forward, right? And be in a position to pay the person if your contract is being carried out, right? If there's a situation of a pandemic, for example, such that the event can't carry on, then it might provide a reason for the company to cancel the event and maybe invoke the doctrine of force majeure, right? But in this case, it is a bit dicey. It is a bit dicey because really we don't know what's to come in December. Even for frustration, because frustration is a concept that must be very fact-centric, right? It must be such that the whole circumstances of the situation renders it impossible to carry out the contract, right? And who's to know whether in December the event can still carry on, whether it can be carried on but with a more reduced extent, and then what will happen then? Would it be an event of frustration? It really depends on the circumstances then. Yeah. But I guess Jeremiah at this time will actually tell you there's a more practical way to solve this problem, right? If we are looking forward and we are going to be faced with such a situation, then what are the options that the freelancers can do when they're negotiating with the event company?
So, I mean, Jeremiah, do you have any practical advice? Because a freelancer is such a difficult situation.
Okay, before I start with the practical advice, I wanted to add on a little bit to Liansheng's point about frustration, which is a common law platform, whether you call it platform or common law usage, so we can get out of a contract by saying, oh, there is a supervening event that is not within the control, and that because it frustrates the intention of the two parties, when we contracted to do something, but something happened that we have no control over, and to make us continue with the event would be very unfair or unjust on both parties. This is something that we can rely on to try and get out of, or to terminate or get out of a contract with. This is what Liansheng was trying to talk about, frustration. Sometimes it may not be incorporated or written in your contract, be it written or oral contract. But it is a situation where you can try and raise it if you want to stop it. I mean, it is beyond my control. Like for example, if the government continues to say that in December, we're not allowed to have an event more than 50 people or 100 people. That event cannot go on. So it may be a cause or maybe a case for frustration for event the client A to rely on to cancel that event, even though right now we are able to have events, but events may not be carried out within whatever it is. So I wanted to add on to that a little bit. I feel that as freelancers, we should always protect ourselves. Unfortunately, at this point, there has been no case law to say that COVID-19 is a frustrating, is a cause for frustration, or is what you call can be used as a reason for frustration at this point. There is nothing in the laws of court. Correct me if I'm wrong, Lianshen. At this moment, nobody has gone to court and used frustration to try to get out of contracts. There is only a temporary provision by the Ministry of Law to stop people from like kicking tenants out or reprocessing hire purchase cars, whatever it is, if they should not be able to pay rental at any one time. But it doesn't mean that you don't have to pay, right? So at this moment, the big question of whether COVID-19 is an act of God or COVID-19 is a cause for frustration is still very much in the air. So how do we protect ourselves? I think for John, the biggest issue right now is that he has a client that he has committed to, and this client wanted to cancel the event. And on the other hand, he's hired a band. All right.
Yes.
And then he has two separate contracts. All right. The band, as far as the band is concerned, I don't care what is a contract you have with your client A, but you have a contract with me. So you need to pay me my deposit. You need to if there is a cancellation, if there's a certain cancellation fee. So a lot of freelancers protect themselves. The only way you can do so is when you have been confirmed an event with somebody, try and make it a divisible contract. Try and make it such that you get paid 50%, 30%, 20%, whatever it is. You know, so when you have money in your hand, it's protection. All right. In the sense that if it's cancelled, at least you've got some money in your hand. So there are two separate issues right now. John vis-a-vis client A. So whether to protect himself, John would have gone into a contract to say, okay, when you confirm that, when you sign a contract with me to perform at this company event, give me a deposit first. The deposit really depends on, it can be 50%, can be 20%, can be 30%. And then what is my subsequent payment? All right. And then also, usually for freelancers, and I would advise that too, that you should have a cancellation clause. Meaning that if you cancel before 1 month, all right, cancel beyond, means you more than 1 month is X number of percentage. If within 1 month is higher percentage, within 3 days of the performance higher percentage, on the day itself is full 100% fee or whatever it is. This is again another situation to protect yourself in that. So that situation is between you and John and the client A. But unfortunately, between John and the band members, this is a separate contract, and unfortunately, if there are more than one band member, they are like a band of 4 or whatever it is, then it is your separate contracts with these people. Again, as you would have asked John to pay you a deposit, you would have paid your band members a deposit as well. And I would also advise the band members to ask for deposit, and then if there's a cancellation, the deposit is forfeited, so to speak. Okay, so this is a very new thing. All of us are learning on the fly at the moment, and a lot of people say, oh, it's trust. Oh, buddy, my brothers, you know, my band members are my brothers. But in a situation like that, you know, brothers also need to eat. So I think the best method to protect yourself is definitely to try and ask for, every time you go into any contract, be it an oral or written contract, whatever it is, ask for deposit, and then try and do a milestone payment. And the moment you pass that milestone, you get the payment. All right. So it is better that way.
Thanks, Jeremiah. I think that's very useful advice in terms of future contracts and how you can, I guess, in more practical ways, manage your risk. Because right now, as you said, legal position not so clear about whether COVID-19 might be frustration or maybe may trigger a force majeure clause. Speaking about the ban, Liansheng, in this situation, is there any possibility where John may ask the client to pay for the ban? Since the client's the one canceling the event?
Actually, I don't think so. I don't think so, because really between the band and the company, There's no contract between them, right? Like what Jeremiah has said, what we have is a contract between John and the band and a contract between John and the client, right? So in order for John to ask the company to pay the band members, there must be an underlying contract, but there isn't. But what John can say, for example, is say, look, because you cancelled my contract, I have suffered a loss. All right, and my loss is measured by the amount of money that I have to pay to the band members because I have pre-booked them, right? And I claim that loss from the company, right? That will be a more accurate way of dealing with this loss between John, the band, as well as the company, right? I just wanted to add one point about deposit, which is very important because even when I advise freelancers, to be honest, people always think freelancers have a lot of time, right? Then they can book people in advance and not suffer any consequences when they cancel events. But I think freelancers themselves must also understand, look, I set aside a period of time for you. That is money, all right? And because I've set aside that period of time, I have to turn down other jobs, and those are lost opportunities for me. And that should justify you asking for a deposit. Okay, and many freelancers say it's so hard to ask for a deposit because they will say, oh, the finance department hasn't approved it, etc., etc. And I say no, like what Jeremiah says, cash is king. It's always good to get cash into your pocket first before you even enter into an agreement, especially when the agreement is going to be a few months ahead.
Yeah, I want to also add on one of the other tricks of the trade, since I've been in the industry for some time, is when a client asks me to book a band or they want this specific band to perform in this concert, right? I would then make it a term in my agreement with the client A that you have asked me to book this band and this band costs so much and these are their terms. So even though the company does not have an agreement with the band, I made my agreement with the band as part of the agreement with the company in that sense. That means you confirmed that I'm hiring this band. Of course, I'm making some money off the band, right? So my contract is maybe worth say $10,000, of which $5,000 is going to the band. So I would put somehow in this agreement with the client that say that my fees are 5,000 and the band fees are 5,000, and make it such that if they cancel the band, they have to still pay me for me to pay the cancellation of the band somehow. Kind of like a collateral contract that I have. So this is an arguable position for me. If the clients cancel my contract, it would mean that they have to cancel the band. Therefore, they not only have to cancel me, they will also have to cancel the band because they've asked me to book the band, even though the contract is between me and the band. So I try and sneak it in somehow like that. I don't know what is the legal position. I think it's quite legal, right?
Oh, it depends on who the parties to the agreement are, right?
Yeah.
But of course, you putting the company on notice of your obligations, right, allows you to, of course, make a better case for your claim.
Yeah. No, I put it in my quotation actually.
Yeah.
So yeah, so in my quotation for the work that I'm doing, for example, I'm hired for $10,000, and then for creative director, whatever it is, $5,000. For booking of this band, $5,000. Even though the band may be charging me less, it doesn't matter to the client, right? I mean, that's between me and the band and the agreement between me and the band. The band maybe is asking me for 4,000, but I mark it up, and marking up is natural, right? So I mark up, say, 30% or whatever it is. So the band quotes me 4,000. I put it in my quotation to my client that my total fee for doing this show together with the band is 10,000, 5,000 for me and 5,000 for the band. They sign on the quotation means that if they cancel both me and the band, they still have to pay me and the band. That's how I do it in that sense. So it is still because it's a quotation and they sign the quotation, it is still valid, legally valid. When they cancel me, it means they have to cancel the band as well.
Thanks, Jeremiah. That's really a very useful tip because it sounds like what you propose will make it easier for the John to actually claim for the band, if the client decides to cancel. And I guess touching on this point, you mentioned about, make sure you have a written agreement. Don't just go by, trust people's words. So let's look at client B, right? And it's unfortunately a very necessary part of, I suppose, being a freelancer, but also very unpleasant, your owe money, pay money session. So does it matter that there is no signed contract?
I want to repeat Liansheng's point. For a contract to be valid, it doesn't have to be written. It can be partly written, partly oral, or completely oral as it is. But at the end of the day, when you go to court, it's a question of what are the terms that you've agreed upon, and what are the breaching, what terms are being breached, and therefore what are the damages that you want to sue upon. And so all this must be evidence. So for me, again, through my many years of experience, a lot of people do not want to give you a contract. So what I can do, if client B doesn't want to give me a contract, I will offer my template contract to client B. And if client B doesn't want that contract, then I will write an email to client B and try and put in point forms what has been agreed between us. So even though it is therefore an evidence of the oral contract that I have with client B, and therefore if we went to court, then the ball is on client B's court to say, hey, Jeremiah has written you an email summarizing all these points that you've agreed. If you didn't agree with it, or you don't accept it, why didn't you reply? So the ball is on the other side. Even though it's an oral contract, there is evidence of what has been discussed. Otherwise, in an oral contract, it's your word against my words. And how do we prove that you agree that my fees are X number of dollars? You agree that whatever terms it is that I'm going to perform at what time, at whatever it is. And all these communications were over telephones. So, or even meetings, I just send the minutes of the meetings, or just send a very simple email, innocuous. Actually, at the end of the day, it's just a simple email. Say, hi, Liansheng, we just met just now. Thank you so much for the lovely afternoon. I just want to confirm that you wanted me to host this event on the 2nd of October. And this event will be from 7 o'clock to 8 o'clock at Shangri-La. You wanted me to just be the MC, and I would require to have a rehearsal with you or a meeting with you, and my fees are $8,000, $4,000 to be paid now and $4,000 to be paid at the end of the event. That ball is now on the other clock. Yeah.
Yep. I mean, out of curiosity, sometimes I think, I'm guessing, right? Maybe for freelancers, they may communicate more through WhatsApp messages. So instead of an email, is WhatsApp sufficient, or you think email is still better?
I would say email is longer, and therefore you can put more innocuous things in there. Whereas WhatsApp is truncated. It's always chop. But you see, at the end of the day, the WhatsApp will become evidence again of what you have discussed or what you are agreeing. It doesn't mean that it becomes the terms of the contract, but it will go towards the court finding out the intentions of both parties and whether these terms are becoming express terms or are they implied. And as a result of that, the court is able to put on the reasonable man's test and say, hey, there's actually this conversation, and Jeremiah puts it over to you in the WhatsApp. How come you never replied? And if you never reply, means that, oh, they may draw inferences against you for not replying or denying it. And therefore, it becomes evidence of your oral discussion that you have with your client. But I would prefer email over WhatsApp. But WhatsApp, no email, WhatsApp also can, or SMS also can. Yeah.
Actually, on the flip side, I think hearing what you're saying, I think it's such a good suggestion that even if your client is reluctant to look at your contract, it's good to send an email or WhatsApp. I said email is better because a bit more subtle, right? You can make it even longer. And you're saying that if the client doesn't reply or say that, hey, I don't agree, so it means similarly, I guess on the other side, it means that if, let's say, the client was to send something to the freelancer, if the freelancer doesn't agree or they think it's inaccurate, the freelancers make sure they don't ignore it and must reply, right? And say, no, I don't agree, or this is maybe what I understand it to be, right?
Yeah. I just want to say here, totally, if a client refuses to answer your emails or sign a contract, I would never continue to work with this client. It means it's very shady. Means that why are they having difficulty to put on record the agreements, the gentleman agreements between the two of us? Is it because from day one they intend to scam me or intend to cheat me? I mean, if the person is not honorable enough to even reply my email and say, hey, we didn't agree to this, let's discuss this again, or even offer me a contract, I'm a bit worried. I will be a bit worried. And especially if the contract is more than a few $1,000s, I would actually want a contract. If you don't have a template, I will offer my template. If you don't want to sign my template, I will put an email. And if you don't want to acknowledge my email, alarm bells. Means don't get desperate, because you may be caught in a situation that you've done all the work and you won't get paid. And if the client refuses to pay a deposit or even discuss a deposit, alarm bells. Again, if the client refuses to pay a deposit or even make a suggestion of what the deposit could be, they can disagree that it is 50%. They can agree on 10% or 20%. At least it's honorable. If the client refuses to even pay you a deposit, as what Liansheng say, the deposit is just to book your time. That means you book my time, so on the 2nd of October, I will not get another job. So if you don't confirm all these things, I put aside this date for you, and then another job comes along, I said no to it, and then you cancel this 2nd of October, I'm left with both, nothing, you know. So I need to protect myself, and don't feel bad about that. Don't feel bad about protecting yourself. It's your livelihood.
You know, touching on feeling bad, you know, I think that John may be concerned that, you know, chasing client B to pay up, you know, he may not want to offend client B. Any practical advice on how you can maybe approach or phrase or, you know, approach it in a more subtle way? Or what do you suggest?
I don't think you need to be subtle. It's all about an honor system, a respect system, and clients who don't respect you, don't ever work with them. I'm not even saying to work for them, work with them, because if you respect my work, you should. If you respect working with me or respect my work, you should pay. And if you have difficulty paying, I don't mind the client being honest about it and say, hey, Jeremiah, we are really very tight. I can't pay you 10,000. Can I pay you 8,000 now and I pay you 2,000 later? And if I have a good rapport with the client, I would say yes. But I hate clients who disappear and then they will not call you, and then after that, the next project that they really need you because their client would want me as a result, and then they try and say, oh, okay, but you still owe me, and if I don't trust you, I don't want to work with you. I know I'm coming from a very privileged situation in that sense that I'm at a point in my life that I can pick and choose. I don't have to worry about when is my next contract or next job coming in. It's a privileged situation, I understand. I know some of the people who say that if I don't say yes, I don't have any job. I better take the job than not to take a job. But my point to you is sometimes better opportunities come on than working with a terrible client who's got a very bad track record of not paying on time, or paying less than what they've agreed to pay. And I will never go back to these clients again. And sometimes you'll be surprised if you raise your fee, they get desperate. They are willing to pay you more. You know, and again, I must confess that I come from a privileged situation because I've been in the industry for some time. But trust me, don't get desperate. The more desperate you get, the deeper you get into the pit of clients not paying or clients paying late or whatever it is. And if you do not want to offend these clients, then you'll never get your money back.
Thanks, Jeremiah. Let's move on to the second scenario. The second scenario deals with an exclusivity clause. Amy is a comedian. Amy signed a contract with a club to perform stand-up comedy from January 2020 to December 2021. Due to circuit breaker measures, the club could not operate. The club told Amy that as she could not perform, they would not pay her. The contract had an exclusivity clause that prohibited Amy from performing stand-up comedy for other companies in the entertainment industry until December 2021. Amy recently received an offer from a theatre group to perform stand-up comedy for a virtual event. Liansheng, perhaps let me seek your opinion on this. So in this situation, can the club choose not to pay Amy?
Again, it depends on the enforceability of the contract, right? So if there's a contract there is an obligation for payment, all right? And then in exchange of the payment, there is a restraint of trade. Then all in, it looks reasonable, right? But if the company wants to have its cake and eat it, right, and chooses not to pay Amy, yet enforce the restraint of trade or the exclusivity clause, then I don't think that's workable, right? It's not reasonable, and I think Amy has quite a good case to say that either the contract was repudiated by the company or terminated by the company.
So perhaps, Amy, given that the contract is until December 2021, and who knows, maybe next year the club may open again, and Amy may want to keep this potential source of revenue. Do you have any suggestions on how maybe instead of immediately saying, oh, you repudiate, I want to terminate, any way to maybe approach or discuss with the club?
Yeah, so there are some ways. For example, I mean, legally speaking, we have something called waiver. So if there's a certain obligation that you want to be waived, so that at least we still preserve the contract, but we don't enforce the obligation, that's something that Amy can discuss with the company. So Amy can simply write an email, say, hey, I'm proposing, because of circuit breaker, you're not going to be opening the comedy club. Can we say for this 6 months, you don't need to pay me, I should be allowed to go and find my own work, right? And then see whether they agree, and then that agreement will constitute somewhat like a waiver, right? Layman speaking wise, there's also a concept of suspending the contract, similar like waiver, where you simply just agree with the other party and say, look, can we put a pause on this contract for 6 months? Let's observe how things are, allow me to do what I need to do, find my own work, go be a Grab driver, and then you don't stop me from doing the work that I want to keep myself alive, to find my own finances, right? That's another way of doing it, suspending. But I think it's important for people to know that in order for you to either suspend, to waive certain obligations, there must be an agreement. So really, at the end of the day, it's up to you to see how you can negotiate with the other party to come to an agreement about it. Okay? But I always tell people, look, you need to know what are the tools you can utilize, right? Because once you know the concept of waiver, you know the concept of suspension, there are certain things that you can negotiate with the company about, then it allows for that communication and discussion to happen, right? Because Amy can certainly say, look, if you're not going to allow me to go out to work, then I'm going to enforce your payment obligation to me, right? And the company certainly doesn't want to do it when he has no money to pay Amy.
Yeah. Thanks, Liansheng. Jeremiah, any thoughts on this situation?
Yeah, two things. First, I think whatever legal rights you have or legal rights or obligations you have, I think it is all very important to look into this relationship that you have with the other party. I think respect, okay, is very important. As what Liansheng said, you shouldn't have your cake and eat it at the same time, in the sense that whilst I stop you from performing, I also won't pay you because I can't afford to pay you. So this honest relationship that you have, that you sit down with the other party to solve a situation, it would be best, and so that should be the first approach, so to speak. What is available out there? What can you do? What you cannot do? Whatever it is. All right. So have that honest discussion with the club, and a club should also be reasonable at the end of the day, because you can't say you can't perform for other people, but at the same time I can't pay you. Right. So what is the best solution forward? The second point is touching on exclusivity clause, or sometimes we call that a restraint of trade clause. I just want to add in a little bit. Usually, whether the exclusivity clause or the restraint of trade clause, when it's presented to the court will look at whether the clause is reasonable or not. There are three things that the court will look into. One is, what is the time factor that I'm trying to bind this person or tie this person to not look for another job in the same industry? And the second question they want to ask is, what is the geographical scope that I'm also trying to limit this person from working, And the third question is, what am I trying to protect? What legitimate interest am I trying to protect from preventing this person from working with a competitor, or protecting this person from working with another company? Is there any thing against the benefit of the company using the restraint of trade clause? So I apply these three into this contract that we have, and see whether most likely would the court say that this clause can be suspended, or can be struck out of the contract that we have. Looking at the time, is until December 2021, and looking at the circumstances, it will cause hardship on Amy if the club doesn't give her any jobs and she can't find any other jobs. So the time factor, if you were to ask me, I think would be in favor of Amy in this situation, because the club can't offer her money, can't definitely tell her that by when next year that she can start performing, therefore they can pay her. All right. Then the second thing is that geographical Singapore, I would say maybe that would be in favor of the club, because Amy is so special. You know, if Amy goes to another club to perform, then people don't come to this club, they will go to another club, and then she will draw the crowd to another club or whatever it is. So maybe in that situation, it is in the favor of the club. But what are we trying to protect? Is there any intellectual property that Amy has of this club that she's bringing to another side? Any expertise, any whatever it is? So on the balance of all probability, I would say that if the club cannot promise Amy that they're going to give her a job anytime before the December 2021, then I think the probability of Amy trying to strike this clause out and go, if somebody else offer and this club cannot match up with the offer, she's probably going to be able to strike this restraint of trade clause or the exclusivity clause. But before you go to court, sit down with the club and discuss and say, what are my options? I have zero income and you're not giving me any money at all. Now I have another club who's offering me X number of dollars. They're opening. Would you like to let me go, or are you going to pay me in the meantime? And settle it in the most honest and reasonable manner for both sides, because you don't want to burn your bridges, right? Yeah.
Thanks, Jeremiah. I think you and Liansheng brought up such key points, or maybe you gave potential points that I suppose freelancers who are in this similar situation can bring up. You know that, look, I need to earn income. You're not paying me. I need to eat, and this other other organization or company has offered me this opportunity. Hopefully, the club is able to see and be compassionate and reasonable about the situation. Liansheng, I heard that there are some government measures that might help freelancers like Amy. Could you give us a quick overview of the schemes?
Sure. I think I did a webinar previously with Patrick as well as Francis, and we were really talking about SERV, which is the grant that is given to self-employed persons. All right, that started sometime in April or May, and it was to give a payout until the end of this year. But of course, if you have applied for it, then you'll be receiving if they have approved the application. Right, that is one. There are also a lot of training grants out there. For example, there is the NTUC training grant. If you attend certain retraining seminars or workshops, you might be paid $10 or $11 an hour, depending on whether you're an NTUC member or not. There are also certain grants out there. For example, I'm quite familiar with the arts industry, so NAC has the digitalization grant. If you apply for it, you might be able to do digital production, and then of course find work for yourself, right? Because if you get a grant, you get to do a project, you are indirectly paying yourself and your peers in the industry as well. Of course, there are also some other resources out there. I always advocate for self-help. So some of the groups that I look at, for example, there is a COVID-19 producers group on Facebook. They're quite active about sharing information with each other, as well as potential engagement or job opportunities out there where they can just post it and then someone will come on and take it, right? There are also certain seminars which are conducted by the Law Society Pro Bono Services Office. There's also an advocate for the arts legal clinic. So if you have questions about your contract, you can sign up for a 20-minute session with a lawyer who will help you look through your contract quickly and give you some advice, all pro bono without having to pay a fee. So there are a lot of resources out there for freelancers. Of course, I also say sometimes joining a union might not be that bad as well. I know of the teachers union. I know of certain artist groups coming together to form a collective so that they talk about best practices, and they're always in tune with the industry practice, right? So you know what's to do or what not to do, right? That's the advice I give to a lot of the young people who are starting our industry as well. When I was younger, I didn't know how to price myself. I didn't know how to, ask for certain terms if I were a freelancer. But if I had a collective whom I can go to and ask and seek advice on, these are the people who have been in the industry for a very long period of time, and they'll be able to give very useful practical tips about it.
Thanks, Liansheng. I think you brought such interesting points that besides, of course, your government measures, which, as you said, it can be found, I suppose you search on the internet, and I think there's a lot of publicity about it. But I think a very practical point you brought up was, find a community, right? And there's groups out there, as you said, on Facebook, etc., where a lot of people are actually in the same boat. You're not alone. And, it's such a good idea to reach out to, these communities out there, so that y'all can, discuss and, I guess also more support as well. So thanks, Liansheng. I think that's really helpful. Wondering, Jeremiah, do you have anything to add or any thoughts?
Again, 2 points. I think the first point is, I understand from the industry of freelancers, there's a lot of anger and upsetness of a lot of people who applied and they did not qualify for the self-employed grants or self-employed allowances, whatever you call that. One of the main reasons why they've been rejected is there's been no evidence of them earning money in 2018 or 2019 because, one, they did not put in their income tax, or number 2, they did not even pay, Medisave or whatever it is to the CPF. All right, but I'm not citing the government here. Okay, I'm not the government's mouthpiece or voice or whatever it is. My point about it is, this is public money. And for the government to give you subsidies as a freelancer, as a self-employed person, they need evidence, they need proof that you have been a self-employed person, especially in the years of 2018 and 2019. And a lot of my friends say that, oh, I don't put in my income tax because I don't earn enough. Now, I think this is a myth. All right, whether you earn enough and whether your enough attracts any income tax payment or not, it's not for you to decide. All right, just put it in, because if you don't earn enough as a self-employed person or as a freelancer, then you will be an indication to the government that this is yet another person who is a freelancer or a self-employed person who doesn't earn enough from the industry, from the income tax returns that he has submitted. All right, so that is very, very important. The government knows that there's a lot of freelancers out there, but they have no statistics as how much they earn. So if you don't earn enough, then it will be an indication that their help is needed in the industry of these freelancers. All right, so even if you think that you don't earn enough money, still put in your income tax return. And if you have put in your income tax return, then there will be a record of how much you earn as a freelancer or a self-employed person. And as a result of that, you would be able to have evidence, and then they would be able to then give you the subsidy as it's provided by the law as it is. Some of my friends who did not submit the income tax in 2018, 2019 because they felt that they didn't earn enough, eventually still got their subsidy given to them, is after a lot of backtracking, meaning that they go and find out the invoices that they have done in the 2018 or done in 2019, and all this evidence, eventually when they submitted it, they actually got the grant or the subsidy at the end of the day. But this didn't have to happen, if you have submitted your income tax. Now, if you are frightened or afraid that, oh, after I submitted my income tax return, I have to pay income tax. But if you think that you don't earn enough to attract income tax, then it is an indication to the government. But if you earn enough to pay income tax, then pay the income tax, for goodness sake, because the money is good for the public good. It's used for situations like this in that sense. And those people who earn more money should pay more money in that sense. All right. I mean, don't try. I mean, they say pay to Caesar what is owed to Caesar. I mean, don't try and avoid. Okay, don't try. I mean, you don't try and evade your income tax. You can avoid it by clever means of getting tax rebates or giving money to charity. You could 2.5 times a rebate or whatever. There are many clever ways of reducing your income so that you don't attract a lot of income tax. But if you earn enough to attract income tax, then be grateful that you earn enough to pay the income tax, no matter what it is, because this will become statistics for the government. And then if the government were to look in the industries and say, hey, we have a lot of people not earning enough to pay income tax, then we need to do something about it. Or CPF. CPF is actually a very good indication of your credit worthiness. And for those of you who are wanting to eventually get married in an HDB flat, for goodness sake, they will look at your CPF contribution at the end of the day. And even if you don't contribute enough voluntary CPF, then at least contribute for your MediSave, because it helps you. Again, I am not the government's voice piece, nor am I advocating, propagating for the government, whatever it is. But in all my 20 over years of freelancing, I've been paying my income tax, I've been paying my CPF, and I believe that I will be reaping the benefits from that eventually. Yeah, this is what I'm saying. To the second point, what Liansheng said, how much should I get paid? This is often a very important question asked by freelancers. A lot of them don't know how to price themselves. Okay, I have two formulas to do that. The first formula is work out on a monthly basis over 3 months how much you spend. All expenses, including rental, phone charges, traveling, the occasional shopping, the occasional travel, whatever it is, over 3 months, you average it. You'll be surprised that you may need 1,500, 2,000, 3,000, 4,000 as expenditure. And then once you know how much you spend, you need to know how much you earn. You need to earn, because otherwise, if you earn less than what you spend, you're actually subsidizing your clients. All right. So if you need to spend, say, for example, $2,500 a month, you should earn at least $3,500 or $4,000 at least. Why? Because over and above paying all your expenses, you still need to save, you still need to contribute to CPF, you still need to pay your income tax. You don't have medical benefits. So if you go to the doctors, at the end of the day, you still have to pay, because we're all freelancers, right? So you cannot earn 2,500 and spend 2,500, because that means you are actually subsidizing. And also at the same time, we don't have 13-month bonus because we're not employees. So if you want to pay yourself bonus, and we all entitled to bonus, and a little bit of frills like the nice Prada bag that you always wanted, or the little travel overseas, whatever it is, these are not luxuries, okay? These are not luxuries. It should be included in your expected expenses. And then you know how much you're going to charge. And how much you're going to charge, you will also look at the 3 axes that I always say. It will depend on your experience, your exposure, your expertise, and finally your X factor. And the X factor is something that you cannot explain, because you may not have experience, you may not have expertise, and you may not have exposure. But if people really like your face and like you as a host, they will pay you more. And this is unexplainable, right? So you need to know your own industry. You need to know how much you need to spend. Therefore, you gauge roughly how much you need to earn at the end of the day. There is no fixed formulas. Ask around. A lot of people won't share information as to what their rates are, but you roughly know what the rates are, and you try and pack yourself with the people whom you think. And if nobody is hiring you, means that you are pegging too high. And if you get too many jobs, maybe you can afford to then raise it slowly upwards. Yeah.
Thanks, Jeremiah. That's very useful advice. Maybe during this time, start thinking about housekeeping, as you said. If you haven't been reporting your income to the income tax, or getting your, I guess your paperwork in order, maybe it's time to consider that, because not only will it help you, but also help other people in the community, so that the government's aware that there is that vibrant number of people, not only the numbers of people, but also how much they would roughly earn. So let's move to our last scenario, which touches on future contracts. So life pretty much moves on, and so we would like to discuss this situation dealing with a future contract. Tom is a videographer. Tom is asked to video a live event for next year. As the future is unpredictable, Tom is not sure how to deal with the risk if the event is cancelled, and any additional cost he may incur if new rules are introduced. The company told him that a contract is not necessary, as the event would be over in a day. Jeremiah, I know you shared some really useful tips earlier on in terms of, I suppose, having a divisible contract, trying to get deposits. Do you have any advice for Tom? Trying to think about, what he should think about, what issues he should consider before agreeing to be the videographer for a live event?
Okay. First and foremost, Don't believe that client that tells you a contract is not necessary. Oh, gentleman agreement, bro, I have you. You know, don't believe that. And for me, even with your best friend, always try and get a simple contract. A contract doesn't have to be 50 pages. It can be a one-page contract that simply lays out the simple terms. A contract just needs 5 ingredients. There must be an offer, an acceptance, there must be consideration, there must be intention to enter into a legal relationship with the other party, and what are the clear and complete terms, which is the most important in that sense. All right. So the moment you have these 5 ingredients, it becomes a valid contract. But terms are necessary because at the end of the day, if there was a breach of the contract, we will always look at the terms. So as I say, right, contract don't have to be in writing. It can be partly written, partly oral, or in oral. So if the company still doesn't want to sign a contract with you, you try and evidence it again through WhatsApp or email or whatever it is to reduce all the things that you've agreed with the company into some form of writing and send it off to the company. And that means the ball is on the other court to deny whatever you have agreed upon. So if something happens to that event, be it a half a day or 1 hour or whatever it is, there is evidence of this oral contract that you have with that person. Because sometimes it's not the person that denies the contract, but it may be the financial controller or the accountant to say that, oh, we never have a contract with you, therefore I don't want to pay you. And the person can be your best friend, but the person cannot do anything about it because it's between you and that person, your best friend, but there's no records for the company, and why should the company pay you? Right? Because company has got company rules or whatever it is. Yeah. So apart from that, we cannot foresee everything in a contract. And that's why we try and protect ourselves as much as we can. I have just received a contract that has put in a COVID-19 clause, which is very vague. It's the event is sometime late next year. It says that by March next year, we will come back to the table to discuss whether the event is going on or not. If the event is going on, I will pay you X number of percentage of the event, and then we will go on. But we reserve the right up till July to say whether the event is going on or not. And then even if we say the event is going on in July, just even before the event happens, we can have the right to cancel the event because of COVID-19. But that other party is very reasonable. They tell me how much I can get as a percentage of the contract. So right now I sign the contract, I get 10%. Then in March, when they say, let's continue with the contract, they will give me another 10%. And then by July, they want me to kick in all the things that I start to plan and whatever it is, they give me another 20%. And then they progressively tell me that if they cancel the event on the day itself, they will pay me 100%. But 1 week before, they will pay me 90%. So as a producer, in that sense, when I start gathering people around me, I will now base my subcontracts with my other contractors or vendors or whatever it is. Again, I'm a very reasonable person, based again on this main contract that I have with this person. And then I'm honest. If he's paying me 90%, I will pay you 90%. If he's paying me 10%, I'll pay you 10%. And integrity and reputation is very important in the industry, because the people entering into a subcontract with me understands that I'm also protecting them, but they also understand that I'm in a very precarious situation. If the main contractor doesn't pay me, I can't say main contractor doesn't pay me, therefore I don't pay you. Okay, I can't say that. So I will phrase it that this contract is in relation to the main contractor, and when the main contractor gives me a confirmation, I will give you a confirmation, this will kick in as it is. And they're all very happy to say that, okay, you're very upfront, you're very transparent, I am happy to enter into this COVID-19 clause with all these various positioning. I don't think that we need to have it like that all the time, but it's really what kind of relationship that you have with your main contractor and with your subcontractors. And if you are very honest, you're very transparent, they're always very happy to support you either way.
Thanks, Jeremiah. I think you brought up such a useful point. You know, as you can see from the first scenario we had, you had a problem with the subcontractor. So definitely moving forward, when it comes to live events or future events, definitely consider, as you said, back to back. If anything happens to the main contract, it will also impact the subcontract. Liansheng, I'm wondering, based on your experience, have you started to see any of these new clauses trying to deal with COVID-19?
Yeah, of course. It could be as simple as tightening the force majeure clause. Sometimes people leave out pandemic, they just rely on acts of God, etc., strikes, warfare or diseases or whatever, and they leave out the word pandemic. So now I'm starting to see more pandemic being inserted into the force majeure. I've also had clauses for certain arts practitioners where, like what Jeremiah has said, which provides for conditional events. So for example, I will divide my work into two phases, right? In this first phase, I'm going to spend this amount of time with you. Therefore, I'm going to pay you this amount of time, right? And then the second phase is conditional on what the government policies or the measures will be in place. And that is subject to further contract, for example. Okay. I've also had people coming to me and say, okay, for they're very detailed milestones, right? Even for filming. So there are, for example, filming has begun. People are saying, look, we can perhaps get the filming done, but post-production work might take longer, all right? Or even certain areas of work might require more time, right? Then they provide for such conditions in the contract as well. So I've seen variants. I've also seen I've not seen an exact COVID-19 clause. So I've not seen clauses where they deal specifically with COVID-19. But they are all talking about it in various ways. Yeah.
Thanks, Liansheng. I'm glad that everyone seems to be, I suppose, taking lessons from, I guess, all the cancelled contracts, the current contracts, and trying to address it in their contracts. I guess in this situation where the company doesn't even want to sign a contract, I know Jeremiah mentioned about how, you yourself can come up with your own template. Contracts can come in all forms and lengths, could be simple 1 page, 20 pages. So I guess, Liansheng, in your experience and your opinion, what do you think are more critical key terms that must be included?
So for example, in this case where they are not, they're refusing to sign a contract, it could be as simple as Tom sending a quotation over and asking them to endorse on the quotation, right? Then within the quotation, you set up, this is the amount, this is the date that you want me to be there. These are the few hours that I must be there in order to film the live event. These are the equipment that I'm going to be bringing with me, or additional manpower if I need, for example, an assistant to be next to me to do filming, right? Or a sound gaffer, or someone like that. So have everything in your quotation. Even a quotation, I've seen a quotation stating, for example, if you cancel my contract 1 week before the event, this is how much you must pay me, right? You put everything into a quotation, send it over, and get the company to sign. It's as simple as that, right? It's not asking the company to come up or ask their legal department to come up with a contract. You yourself can do something as simple as that, right? And I always tell people, you need to be very clear about a few things, right? One, you must know who the parties are, right? You must know what your payment terms are, right? You must know what are your obligations, right? You must know what are the milestones, what are the deposits, what must be paid. So these are the obligations, right? Then, of course, there are a lot of other things that may be what I say collateral. So, for example, like IP rights, right? Who does it belong to? Is it really important to you? Sometimes for a photographer, it might be important because they might want to sell their photographs against someone else. If they are working for a certain company, will the company be allowed to use their photographs in other jurisdictions, for example, or just in Singapore only, right? Then, of course, the last thing is, what is the exit clause, right? What is the termination clause, right? When can you terminate this contract? So really 5 big things that we are looking at in order to make sure that the terms are there.
Maybe this is,
Yeah.
I think the difficulty, I suppose, for freelancers is that, I guess first, they may not earn as much, and, let alone, I suppose, incur legal fees to get a contract done. Wondering, Liansheng and Jeremiah, do you know of any template template agreements out there that the government has put out, or any associations has put out?
Okay, before I answer that, I really need to put in one point that I really want to break the myth that contracts are not negotiable. Contracts are negotiable. Okay, even if you are trying to have a contract with a very big producer, a big company, MediaCorp or SPH or NAC or whatever it is, and they give you a template, right? You can go through each and every term. If you agree to it, agree to it. If you don't agree to it, offer what you don't agree with it about and offer a separate term. They are all negotiable. All right, don't say yes to a contract with terms in there that you don't agree to. At the end of the day, you're being forced to do something that you don't want to do. If it's within tolerance, meaning that I don't really like to do this, but it's in the contract that I must do it, then if I can do it, I will do it. But if you really don't want to do it, like for example, I don't want to be naked for a scene if I'm an actress or an actor, and it's in the contract, you can negotiate for that term to be taken out. And sometimes you'll be surprised that the other party actually is trying to put in all the terms that they wish. It's a wish list. And for you to come back and say, what are you willing to do and what are you not willing to do? What are you willing to be the terms to agree upon, and what are the terms that you don't agree, and you don't agree, what is your alternative terms? So I break that myth that contracts cannot be negotiated. All right. And if you don't like the terms of the contract, don't sign it. You can always find a job elsewhere. Right, now back to the question. Sorry, the question was, Serene?
No worries. The question is, I'm just wondering, is there any, you know, I'm hearing from the discussion, templates. Is there? I'm not sure. I'm just asking.
There are actually many templates of contracts. All you need to do is type in templates and the industry, and some of the contracts are from Singapore, some may be in America, some in the UK, whatever it is. It is a minefield. Whilst I encourage people to look at other contracts, but it also takes a little bit of a legal knowledge to know what are applicable in the Singapore context and what are not applicable to a Singapore context. If you are actually hoping to do a general template for your practice, that means if I'm a producer and I do a lot of events, then I would like to do a template for me to sign with my clients and a template for me to sign with my subcontractors or the performers or the bands, whatever it is. I will do this template and run it through a lawyer first. Just spend that $200, $300, whatever it is, get your template sorted out. That means this basic template is something that you really want, making sure that all the terms, the language is correct, because sometimes when you cut and paste from different templates, right, the language, the tense is different, the terminology is different, the way it's phrased is different. It doesn't mean that the more legal sounding the contract is, the more legal it is. It's not. We're all going towards simple English in that sense. So if you're trying to do a simple template for your own practice, right, run that simple template with a lawyer, and then from then onwards, just use it and then change whatever terms that you require for that particular project or for that particular occasion. You will have a basic as a result of that. Googling and Googling templates is one possibility, but it may not be a very good, wise choice if you are not discerning enough to know how to cut and paste and join them together. It can come like clause 17 is in contradiction with clause 23, you know, and you are not aware of that at the end of the day. Yeah.
Thanks, Jeremiah. I hear where you're coming from, and I think maybe something from everyone to consider. As much as you can take inspiration, from what you can find on the internet, but at the end of the day, it's still a legal document. So it may be useful to consider whether if you're starting out, maybe just invest in a little bit in trying to get a template out, which you can easily tweak and use it for your own. One interesting point I feel, about this COVID-19 and being so unpredictable, there's new laws, new measures that's happening every day. When you're an employee working in a company, your company would always tell you and update you saying, hey, there's safe distancing, you must sit 1 meter apart or things like that. But when you're a freelancer, I guess your client will very much expect that you already know all these measures. Any advice in terms of how do you keep up to date with all these new rules and laws? Maybe Liansheng, if you could share that.
Sure. I know of certain industries where they band together and they come up with updates. So, for example, I hear a lot from the Singapore Association of Motion Pictures Professionals. I mean, when the government started lifting the measures and allow for filming to begin again, what are the rules? The Singapore Association of Motion Picture Professionals, they come up with such simple info booklet to tell you, okay, how many people can be on set? Must you wear a mask? What must you do, etc., etc. Okay, and generally different industries they'll start to share this information with each other because everyone is trying to get their work done, right? So again, it's back to self-help. It's back to getting yourself glued into a community so that you have people to ask. It's the same thing with contracts. Jeremiah was saying, you know, if you don't know, if it's the first time, go and find a lawyer, go and ask. I always tell my the people who come to ask me questions, look, does this contract look different from the other contracts you have signed? Are there queries that you want to ask? For example, why is the funder like NAC asking for your full intellectual property rights? What does NAC want to do with your intellectual property rights? Ask them. And if they have a good reason for putting that clause in the contract, then you understand where they're coming from. But if they tell you it's a standard template, then ask further. Ask them, do you really need for these clauses to be in the contract, right? Do you need, can we find a way to tweak it such that, you know, I give you certain license to use and then I keep the IP for myself and I can use it somewhere else, you know? These are things that really, if you ask the right questions, you might find out new things about the contract rather than just accepting it as it is. Yeah.
Thanks, Liansheng. I heard that there is, you mentioned earlier about advocates of the arts. Wondering if you could tell us more about that.
Yeah. So there is two programs. One is a booklet. Okay. The Law Society Pro Bono Services Office has actually come out with a book, which Jeremiah is holding up now. It's called Advocates for the Arts. Yeah. They are very good bite-sized information about various areas of law for the freelancers or people in the arts industry to look out for, including template clauses. Right? So
okay, that's good.
Yeah. So if you require certain templates to put in, all right, you can pick and choose and then merge it into a contract, and then they will even explain to you about intellectual property, about employment rights, etc. Right? Okay. I'm also quite familiar with the Arts Resource Hub. I know the Arts Resource Hub has a website. The website also has certain clauses which are taken from the Advocate for the Arts book. The clauses came from an experienced contract lawyer. I think it's Jukin from Morgan Lewis Stanford. So there are a lot of template clauses out there. But of course, like Jeremiah says, sometimes you need to be a little bit knowledgeable in order to know how to piece things together, right? So that's the first part about Advocate for the Arts, the booklet. There is also a program which the Law Society Pro Bono Services Office run, which is called the Advocate for the Arts Clinic, right? Where freelancers or art practitioners might feel that they need some legal assistance to address some queries they have. So like I said, it's a 20-minute session. It's free of charge. You write into the Law Society Pro Bono Services Office. They'll pair you up with a pro bono lawyer who can help answer some of the questions that you have.
Thanks,
so I just want to jump in. I just want to add on a little bit. This book, though it's a physical book, it can also get the PDF version of it from the Law Society Pro Bono Office website. For those people who are very environmentally friendly, you can click on to this book, the PDF, and download it as it is. Also, if you want to have any of the clinic sessions that Liansheng has mentioned, you can book a session. Also, when you see help, again on the top bar, when you help for the community, you can click onto it, and there are more information about the clinics online as it is. We used to have a lot of free legal advice clinics with the Law Society's Pro Bono Office, but unfortunately we have to suspend the actual face-to-face at this moment because of the COVID. So we are just going online there, but you have to register for that. Sorry, Serene.
Thanks, Jeremiah. Oh, no worries. I just wanted to ask you a quick question. I think Liansheng had shared a bit about how to keep up to date about new laws and rules. Any practical advice on how to keep up to date? Read newspapers, or what do you suggest?
I would echo what Liansheng said. Ask. Be curious. Ask from the community, because I think what Liansheng has mentioned earlier, if you know that there's a community out there that specifically in the industry or the trade that you're doing, try and join the community, because, like for example, I have a wonderful producers Facebook link, and they actually post in a lot of updates and information or new grants available, new projects available. They're looking for another producer for this project, whatever it is. And then if no question is ever stupid or silly, if you need help, ask. So you can post it on that community, be it the Facebook or link or whatever it is, and then ask them questions and say, oh, I have this. Anybody who knows the answer. Prior to COVID, I think people are a little bit more reserved, a little bit more, oh, my knowledge is my knowledge, and I don't want to give you my knowledge because you have an advantage over it or whatever it is. But I think since COVID, we are actually seeing the better of human being, better of everybody. And I've never seen freelancers so open, so openly sharing, so caring for each other. And I'm so happy that this is happening. And so maybe this is one of the best things that ever happened as a result of COVID-19, that we are more united as a group of people, because we realize that as freelancers, we have no one else to depend upon apart from ourselves and our friends and our fellow freelancers.
Thanks, Jeremiah. Let's move on to the Q&A session. As a reminder to our audience, you can still submit questions to the questions panel on your screen. So our first question, I think, touches on, we were having the earlier discussion that you may not necessarily need a contract to be in writing. You mentioned about, dropping an email. So this participant had mentioned, well, sometimes people also do communicate through direct messaging on Facebook or on Instagram, right? DM each other, or also besides WhatsApp. So if you would communicate with each other over DMs or WhatsApp, would that form a valid binding contract? Maybe ask Liansheng. Yeah. Sure, then after we'll follow by Jeremiah.
Trick question, but Liansheng will answer first.
Okay.
Yes.
Same thing, right? Insofar as a contract, Jeremiah has explained, he says there are 5 elements. Usually for me it's 4. You look at offer and acceptance as 1, whether there's true offer and acceptance, whether there's consideration, meaning whether there's a tangible benefit, right, that's being offered. Right, then you look at, of course, whether there's an intention to create a contract, okay, and then the shit, I forgot the last one.
Certain and clear terms. Certain and clear terms.
Yeah, the terms, right? The terms. Okay. So that forms a contract. Insofar as whether WhatsApp direct messaging forms a contract, really looks at the circumstances, and like what Jeremiah says, he goes back to, for example, if you really do need to go to court to prove your case, right? The person trying to prove the case will have a lot of difficulty trying to pull all these WhatsApp messages together to form a coherent picture of what is being discussed, right? But if you do everything through an email and there's a thread that really goes through, right, then it's so much easier to prove what the terms of the contract were, what was the discussion, what were the amendments made to this agreement, what was the agreement itself, right? Same thing with oral agreement. We would never say that an oral agreement is not an agreement, but we always say, whose oral agreement is it? On whose term was it agreed on, right? And if we don't have the extraneous evidence of writing, documentary evidence, how do you prove that your version of the oral agreement was the oral agreement that people agreed upon? Yeah.
So I would like to add,
yes,
I agree, I concur exactly what Liansheng says, but at the end of the day, it's all about evidence, all right? So it will be easier as evidence if you put everything together, even through a DM, WhatsApp, whatever it is, gather all those thoughts, put it into one email. And then the person can deny or add on or change or whatever it is. All these are negotiations of a contract until you come to an agreement as to what these terms are. And then, even though you don't sign a contract, this will form evidence to the intention of what you have agreed, what you have actually agreed, so that the court is able to find out, were these terms agreed upon? And if these terms were agreed upon, were there a breach of these terms? And if there was a breach of these terms, what are the damages suffered as a result of that? All right. So, I mean, best thing is to have it in writing, right? But if you don't have it in writing, even when you have it in writing, then you still need to evidence the negotiation, the discussion, to give intention to the both parties, as it would be. So it's really, at the end of the day, is you hope you don't go to court, but if you go to court, it's all about evidence.
Thanks, Jeremiah. One interesting question, we've been talking a bit about, all right, even if it's a verbal conversation, you can drop an email. So this particular member of the audience is interesting. So instead of providing a quotation, what they do is when they issue their invoice would contain all their terms and conditions. So if you have so after you agree on the on the scope of work, and when it comes to the time to pay, you issue an invoice. Your invoice have terms and conditions, which may not have been discussed earlier. Does that form part of the contract? Maybe Liansheng, what do you think?
It really depends on whether there's an offer and acceptance, right? Sometimes some people will argue and they say, look, how come your invoice has an interest payment? If there's late payment, right? We never discussed this, right? And then you snuck it in your invoice. To me, really do it through a quotation first, get the parties' agreement, work is done, then you invoice for it. Okay, because that's how it should be done. When you wait till the invoice is rendered and issued to the other party, it's very easy for the other party to come out and say, no, I don't agree to your invoice. Actually, you overcharged me. Actually, you didn't do this much. Actually, how come you invoiced 2,000 when you only work 4 hours instead of the 6 hours that we agreed upon? So leaving it to the invoice to me is too late.
An invoice at this moment may seem like a unilateral contract, so to speak, because if you have a quotation, best to have the other person sign or endorse the quotation, and that quotation will become the contract or the basis of the contract. That would have identified all the terms and conditions of all the obligations and the rights and payment issues, when to pay, how much to pay, whatever it is. That quotation would be the best because it would be the start of the project or the start of the relationship that you have with the other party. I do completely agree with Liansheng that when you send the invoice, it may be too late. Or maybe the invoice is an interim invoice. They may disagree, and then it may sour that relationship that you may have with the other party because I didn't agree to late payments, or I didn't agree to this term. We never agreed to. Why do you put it in the invoice? So definitely put it in a quotation rather than invoice.
Thanks. A practical question I received was, I guess this freelancer has already a contract and quotation, and they sent it to email or WhatsApp, but the client is too busy to sign and get back. So can we take it that even though the client did not respond or did not sign the contract, is the client bound by it?
Well, it depends.
Go on. Sure, Jeremiah, go ahead.
Okay, it really depends. If it's something that you have sent across, and you, as a result of that, okay, you send the quotation over, and the client tell you go ahead, and he hasn't signed it. By conduct, he's already agreed in the acceptance of the quotation, or in the acceptance of whatever you sent over. You say, oh, go ahead, I will sign it later. So by conduct or by the agreement, the contract is already signed, sealed, and delivered, so to speak. All right. However, you must be very careful about it. There are very sneaky clients who don't really want to honor that the email or the contract they sent over. They kept quiet about it, making you do. But at the end of the day, if then be an evidence in court that I have sent it over on such and such a day, why did you take 30 days or 60 days to reply my email? And in the meantime, you've led me to believe that this is the agreement that we're going according. And I've done a lot of work according to this direction that I have sent the proposal and the quotation and whatever to you. Now the ball is on the other court to deny it, or to address to the court, or to show evidence otherwise. So at the end of the day, it's all about evidence, evidence, evidence.
Yep. Thanks, Jeremiah. Maybe I'll deal with one last question. I think so far, you gave really good advice in terms of, trying to get a deposit or split up payment. But how do you deal with it if it's a very small job? Maybe it's $100 or $200. Any practical advice on how to deal with those type of situations?
If it's $100, $200, what is your loss? $100, $200. But if it's a $10,000 job, okay, and you only get the $10,000 at the end of 6 months, the risk is very high. So if you were to ask me, if it's just $100, $200 job, do it and then get the money at the end of it. And if it doesn't pay, then you never work with that person ever again. Whereas the risks are much higher if it's a $3,000 job, $5,000 job at $10,000, and maybe to the extent of $100,000. You can't afford to wait for payment for $100,000 after 6 months. And what are you surviving on in the meantime of 6 months? I mean, I always ask my clients, right? Are you being paid a salary every month? They say yes. Then how do you expect me to live if you are only paying me my amount at the end of the project, which is 6 months later? And here I will have to make a decision. If my client is not sympathetic to me regarding this point and refuse to pay me milestone payments or divisible contract payments as per every month or as per every milestone that I do, they pay me an X number of dollars of that $10,000. This is a client that I don't really want to enter into a relationship with.
Thanks, Jeremiah. I think you can squeeze in one more question, and I'll address this question to Liansheng. So this is, I suppose, an educator or a trainer where they agree that, for every term in a year, they agree that, all right, they will be free to commit to a certain number of sessions or lessons. So let's say they agree for every quarter, they will commit, they're able to teach for, let's say, 4 lessons. But sometimes the school may not fulfill the full 4 lessons, maybe 3, maybe 2. In such a situation, is there any way for this trainer, I guess, to ask the school to pay for those sessions that it did not fulfill?
Again, it depends on what does your contract say, right? Is it payment upon you providing the time to teach? Okay, or is it, there are certain contracts which I've seen where they provide a minimum number which you must teach, and I'm obliged to pay you for. Okay, but I expect that it may go from maybe say the minimum number is 10 hours, but I expect for this month you may teach up to 20 hours, and for the next 10 hours I'll pay you this amount of money. So if there's a base rate that has been agreed upon, maybe you can insist on that base rate, and everything else is dependent on whether you have actually fulfilled those hours. Right, so it goes back to what your contract says. That's one. Another thing that I've also seen, for example, is whether they are allowed to bring forward or carry on their hours to the next month, for example, if they don't teach, right? And will they get paid only when they actually do complete those teaching hours in the next month?
Thanks, Liansheng. I think one quick question was, earlier I spoke about small amounts, 100, 200, okay, let's say maybe 1,000, 2,000. For these sort of claims, it's obviously too expensive to go to court. Are we able to go to the small claim tribunal?
Yeah, so
Liansheng?
small claims now cover up to $20,000 in claims. All right, covers a certain few categories of contract, and provision of services is one of them, right? That's where the evidence is important, right? Small claims is an arena where lawyers are not allowed to be participating in. It's really the parties coming together, going through first the mediation process, and then later, if mediation fails, a court adjudication, right? The mediator or the court will actually be looking at what documents you have, right? And if you have streams and streams of WhatsApp messages and trying to prove, what exactly the terms were, it's going to be quite difficult for you to argue your case with such, messy evidence. But if you have things that are contained much neater, where things are more expressed, then it's easier for you to argue at small claims and then say, hey, look, you really should pay me this number of money because I've done this amount of work, right? Back to just now the question about, what happens if the quotation is not signed, right? If it's the customer calling you and say, yeah, I will sign, okay, I'm okay, please go ahead and do the work, right? Then stick in a message or stick in an email and say, hi, so and so, thank you for the call just now. Okay, as agreed, I will continue to work, or I'll start work based on my quotation of this date. It's just a two-liner. It's as simple as that.
Thanks, Liansheng. I think that's very practical advice. In the situation of, if your client doesn't respond or sign the contract and say, hey, it's very urgent, please start first. Good to drop that email to just record down basically what was agreed or what was said. I'm afraid we have to bring our Q&A session to a close. So please remember to download the resources from the Files tab on your screen. We hope that you found our webinar informative. As you can tell, there's so many different legal issues that is unique to freelancers and to the arts. Do visit Law Society Pro Bono Services, the website, to download your free copy of the Advocates for the Arts Legal Toolkit. Maybe to give also a little bit of background about Advocates for the Arts. Advocates for the Arts is a law awareness initiative which seeks to equip persons working in creative industries, in particular freelancers, with better awareness of their legal rights to support their creative endeavors. Another resource is the COVID website, which has been created by a group of NUS law students who saw the need to support the community. So this is a potential resource for you to be up to date on the latest COVID laws. Please visit www.nus-covaid.com. After the end of this talk, we will be sending a survey link for your feedback. We appreciate your comments as it will be used to improve future webinars. Thank you again, Liansheng and Jeremiah, for sharing your knowledge and experiences with us. On behalf of the Law Society Pro Bono Services, thank you for joining us today and have a good week ahead.